Okay. Just let me know whether my voice is audible and the slide is visible. Okay, so thank you, Vishnu and Francie John. Okay, so let's start the session. So already, I think, like they have waited for 5 minutes. Let others to join. In the meantime, like we can go ahead. We don't have to wait for too long. Okay, so yeah, the session is about administrative law. Hope you might have heard about this. Administrative law, it's some kind of like we can't say it is more relevant to business law. Business law, it particularly like speaks about it, particularly like gives you an overall idea about what are all the like the legal like the compliances which you have to follow when you're running a business. That is between business to business, between like companies, between like two different companies or like many companies within a particular industry, or like we can say between industries. But whereas administrative law is like to an extent is almost like a business law, where contracts are there, offers are there, and acceptances are there, and the legal compliances are there. Everything is there. The only difference is this is between the government and other business. So business law is completely about the legal compliances which you have to strictly follow, enact, like contracts, sign contracts, agreements between companies and companies. Whereas administrative law is all about the contract and everything, like the business proposal is everything, between the government and the businesses. So yes, we can start with, like a definition. So it serves as a regulatory framework that governs our commercial world. That is not, it serves as a regulatory framework in the sense, it gives a clear cut of like regulations to the parties who are involved in this business proposals. That is not like either the government will be offering the proposal, the company or an individual organization will be accepting the proposal and like go on with providing the service, or on the other hand, the individuals or organizations will like come with a proposal. The government, like the bodies will accept the proposal, and like yes, there will be like negotiations happening, and like the service will be done. So it's a regulatory framework. That is who everyone in the this administrative law concept context. So everyone will be knowing what are the regulations like laid upon and what they have to follow. So key areas include insurance regulations, that is who is going to take insurance, who's going to take the responsibility for the actions happening, contract management, and the taxation laws. So since it is like a government related activity, business activity, so there will be like taxes, so taxation laws. So under which law who is liable to like pay to which person, that is not to which entity, and sales transactions, how the sales is going to happen, whether the individual organization is selling something to the government or the government is selling some to the individual organization. So sales transactions and agency relationships. So administrative laws create order in the chaos of commerce, because if you don't have like a proof of a contract, a proof of agreement, a proof of like the authorization of like both the parties who have come together and like signed in the contract or signed in the agreement. If that is not there, then like all the commercial transactions, that would be in completely chaos, because either one like will be blaming the other one, or either one will be like trying to manipulate the other one. So there has to be a legal contract. It's as if like you are going to like rent a house or buy a house, and or like take a lease of like a house or an apartment. So there is a contract like to be signed by you, like because you're going to rent it or take a lease for it, and the provider has to sign the contract. Imagine if there is no contract, There is no contract between like you and the provider. So what happens is there will be chaos, of course, because like if something happens, like bad happens, like afterwards, so either one of you blaming the other one. So contract is very important, not only when the business activity is happening between business and business or business and individual. Contract and like all the legal compliances or like very much required. It's mandatory when the business activity is happening between the organization or an individual and the government. The sources of administrative law, how these administrative laws are like enacted, what are all the like from which major sources a government usually like enacts this administrative law. So it depends on the countries, like different governments, like in different countries. So they come upon with many policies. They come upon after like many discussions, like with the higher officials, diplomats, the political uh, party members, and they call the like the lawmakers. Like with the consultation and discussion with everyone, finally they enact administrative law. Now, finally they enact the administrative law based on many legal frameworks. The first one is mercantile law. Whether it is India or like USA or like any country in Gulf region. So a mercantile law is something like the historical foundation from the colonial period or historical foundation like for I mean when the country started like forming a government for ruling it. So previously usually like it was this rule, no monarchy rules, no kings were ruling. But after that, when the government, like when the king's monarchy, like that ended, and when the government started ruling, people. So then, from then onwards, these laws were like enacted. So mercantile law, it has its very basic from the historical foundation from the colonial period. For example, take India. So few laws, we have here, it's from the colonial period in the sense. So we were colonized by the Britishers for at least like 150 years. So the first law, mercantile law, we have like in India, like now it is like the business contract between the the government and the individual person or the organization. That is any person who is running a business, any person who can fulfill the government like expectations from any of the government body is eligible to like apply for the contract, eligible to apply for that like for getting the contract. So there is no like a discrimination in the name of religion or in the name of like caste or in the name of like social status. So there is nothing like that. So any organization or any individual who has the capacity to like supply whatever the government body has like demanded. So they are eligible to apply for a contract. So this is a like the foundation, the mercantile law foundation of our country. So especially like it was from business. I mean, especially it was like after the colonial period. Before that, when the colonial period was happening, when colonization was happening, and even before that, when kings were like kings and queens were ruling us, this was not the case. Many discriminations were there, like giving like more importance to like the a particular set of people or like particular set of like business individuals. That was happening like before that. But after the independence and everything, so now the things have like changed. Adapted to international business practices, that is other source of the mercantile law. So the law which a country, a government like takes up as its main like consideration. So it should be relevant with the international business practices as well. So it shouldn't be something like which is making the country or making the resources like so isolated from the international like businesses or from the international governments. It should be something more friendly. You can't like held up the resources for a very long time, hold up the resources for a very long time. What happens is after some point of time like invasions may happen. So any government, no, like any country, any government ruling the country has to know, like be open up about the resources it's having, and they should be ready to know, like having the business proposals, no, with other party members who are in other countries as well. So they should be open. They shouldn't be, no, like so secluded, so isolated. What happens is, no, like after some time, the economy of the country, no, like it may not be, no, like it may not be flourishing, and individuals, the basic needs of individuals or the basic rights of individuals, no, like that may be, no, like affected. Example is, no, like North Korea, so they are not sharing the resources with the other world countries, they are not sharing it. So import and export, no, like they have very strict regulations. So what happens is, they are not adapted to international business practices, they have their own practices, which doesn't comply with the international business standards. So now it can be, no, the country can be, no, like seen like, no, like they are doing good, but after some time what happens is, every individual business or no, every individual persons, the basic like the rights of, no, like the citizens, no, so that will be, no, like completely crushed. So obviously, no, what happens when you give more pressure, or no, like when you no, like suppress something, no, like suppress people for a very long time, so at one point, no, like it will burst out into, no, like something other, which is not good for the country, which is not good for the government as well. Now next one is country statutes, that is the second source. So these country statutes or the laws enacted by parliament or the White House or whichever government is, no, like ruling that particular country. So those politicians who are in the higher positions, those diplomats, so they sit together, they pass the bill, they come up with a conclusion, and no, like finally a voting will be done, and finally, no, like they will come with a result. So those laws are enacted by those parliamentarians or the politicians, no, like whoever is in the White House or whichever government, no, is ruling that particular country. Second one is tailored to local business needs, because they know what is their local business needs. So if US is, no, like enacting a law, no, like so completely it will be based on the local business needs. There is no, the business is happening within the US. So based on that, they will be, no, like coming with those laws. So country statutes are the second source. Third one is judicial decision. So here the court, Supreme Court or High Court or no federal court, whatever it is, no, of a country. So that comes into the scene. So court precedents and the interpretation. So they interpret the information. So according to the law or something, no, like that, they will be having a courtal law, right? Courtal law. So according to that, no, they will be giving suggestions. They will be asking the government to make changes, editing the changes, adding few more things, or no, like deleting, taking out few more no, like regulations. So the judicial interpretation inference will be there. So living law that evolves with the society, because this is completely done with the society in mind. And the fourth source is customs and usages. So every country will be having different customs, every region will be having different customs. So traditional business practices, so that will be considered, and industry specific conventions. So all these are the resources, so from which the administrative law will be enacted by the government, plus the the administrative parties, plus the judicial parties. So all these will be considered before, no, enacting the administrative law. Finally, it will be, no, like passed in, the bill will be passed in, or it will be, no, like accepted by majority of the people, or majority of the politicians, or the, no, like the administrative people who are in the higher position. So once it is, no, like the bill is passed, it will, no, like come into enforcement. So this is how, no, administrative law was enacted. It keeps on changing, it is not a fixed thing. Not major changes will not be happening, but minor changes, of course, it will be happening, no, like from time to time, according to the government. No, when one government is, no, like uh has gone and the other government has taken up the chair, so obviously they will try to, no, mend few things, no, with the existing law. So that happens automatically, it happens. Okay, now coming to contract. So contract is a the main legal, like the document which is supporting the business. Actually, no, it supports that the business has actually happened. If there is no contract, it means no, like the business is no, like only in no, like words. It is not solemnized. It is not, like registered. So only when two parties know, like entering into contract and signing the agreement, signing the contract, then that becomes a legal entity which can know, like support in like in times of conflict between these two parties. So in administrative law, contracts play a vital role in facilitating the functioning of government and public authorities. Here's a structured explanation. First one is legal framework for government dealings. For any government dealings, so it strongly acts as a legal framework. So if you have signed a contract, the other person who are no, like who is doing business with you has signed the contract. So both parties have signed. You have this no, like a strong legal foundation in hand. So in future, when the business has no, like started, when the like transactions are happening, when the services are no, like being exchanged. So in case if there is no, like any flaw, in case if there is no, like any misinterpretation, or in case if there is no, like any error, in those cases this legal contract, it no acts as a strong legal foundation. You can approach to know, like any higher authorities, no, like with have by having the contract in hand, no, which is that is a solid proof. So these are often referred to as administrative contracts or government contracts. So it is between the government and the public, any public agency or any public company or a private company or an individual. So the contract is called as administrative contracts. But if the same contract is being signed between two businesses, say two private businesses, or between a business and an individual, so that's something different. That's a contract. That's a business contract. Whereas here, this is between the government and the organization. So it's called as administrative contracts or government contracts. The second point is ensures accountability and transparency, because all the terms, conditions, regulations, and everything, no, like will be mentioned in the contract. Everything. That is not like party A, what his or her responsibility is, what party A should be called, and what party B should be called. Who are all the parties involved in this, no, like business activity, and what are the names, and no, like the address proof, and no, the complete proof of them, and what is their role, responsibility, what is the time frame of this contract, till what time, no, this contract is valid, and if at all, no, like either of the party has no, like not followed the like the rule or regulation which is mentioned in the contract, so what action can be taken against them. So everything will be like clearly mentioned in the contract. So that's why it ensures accountability and transparency. The third one is enables public services and infrastructure. So though through contracts, like governments can like procure goods and services, undertake infrastructure development, partner with private entities like to collecting toll fees at the toll gates and everything. So all these come under like enabling the public services and infrastructure. The fourth one is subject to judicial review. There is no like since the contract serves as a strong legal compliance document, so you can like approach any judicial authority, like any judicial entity, to prove your prove your entitlement. So this can be done. And fifth one is special rules apply. That is, unlike private contracts, administrative contracts often require statutory or procedural compliance. So private contracts, like that doesn't have to be, like signed by uh, a strong, say a notary public or something. Say, for example, myself, I and my, house owner is entering into a contract. It doesn't have to be like signed by a notary public, or it doesn't have to be signed by a a government authority or a government personnel. So because it's a private contract, it's a private contract between me and my like house owner. Like we are both are entering into a contract for renting his house or her house, or for taking lease of the house, or whatever the matter is. So if it is a government contract. But in case I am lending or no like leasing, I'm sorry, I'm not like renting or leasing something from the government. So that property belongs to government. I am taking lease of it. I'm not renting it. I'm going to buy it. Then no like extra no like more statutory and procedural compliances will be there. And on the other side, if I am no like renting or if I am giving it to government, any of the government entity, or I'm going to sell it to sell it to the government, I'm going to know like rent it to government, I'm going to give it lease to the government, then again no the same rules apply. So they may be subject to cancellation or modification by public law powers. And sixth one is no absolute immunity. So while the state is a sovereign, it is not immune from contractual ability. That is, be made in the name of the president or governor, be executed by authorized person. So otherwise, they may be void and unenforceable. So it's not like, say, a part of, say, the public works department. So they are no like offering they are giving an offer that anyone can know like lay road in a particular highway or in a particular area, and they can collect the toll for it. So no like I'm going to know like a bid for it, and they are giving the bid. I'm going to know like take the bid. I'm planning to take the bid. I'm no like my company is planning to know like lay road, and my company is planning to collect the toll. In that case no like the contract, it will not be between that particular individual who is in the department and me. So it will be the government contract. So it will be considered as a government contract. So it will be having the the signatures and the approval of the highest official in that particular department, the very highest official. So this is how like government contract works. It is not between an individual working in that particular department, or it will not be between the department and me. It will be like between my company and the government entity, and it will be signed by the highest official of that particular department or in that industry. So there is no absolute immunity. Then seventh one is protects public interest. Contracts in administrative law serve not only individual parties but large public goods. So remember, contracts in administrative law ensure public administrative, public administration functions effectively, fairly, and legally. So they bridge public obligations with private rights and are subject to constitutional and judicial oversight. In case if I want to know, like cancel the contract, if I want to make a change in the contract, have to modify the contract because I'm not able to know, like complete the task which is like mentioned in the contract. I need more time, or my company feels that like there was something like error which has happened from the government side and not from our side. So in those case, yes, I can very well like reach. I mean, I can very well like go to or get any judicial help for that matter. So it is not that since it is a contract between the government and a private organization, the private organization cannot do anything. They can do. They can do if they feel that like there is the contract is being like void in the sense. Void in the sense it's not like in use anymore, because the government has not not followed the rules and regulations which was mentioned in the contract. So in those cases, even the private companies can like get judicial help and get compensated as well. If proved, then they can get compensated as well. So what exactly is a contract? All contracts are agreements. So all contract you can call as agreements, but all agreements are not contracts. So that is a difference. You can call all the contract as agreements, but all agreements are not contracts. So an agreement that the law can enforce is the contract. Otherwise, it is not called as a contract. It's just an agreement. So the reality check is contracts are legally enforceable agreements, and void agreements is cannot be enforced at all because it's void, it's nullified. Because of many reasons, it is nullified. So it cannot be enforced. So under law, it cannot be enforced at all. And voidable agreements are enforceable by only one party, that is either of the party. If either of the party find the discrepancies has happened, then which is not mentioned in the contract, then yes, of course, they can they can go to the higher officials or the like the judicial entities for like enforcing the contracts. So this is all about contract. Now let's see how the contract will be formed between the government and the individual organization or a public organization. The first step is offer or proposal. So any party has to, either of the party has to offer something, that is propose something. That is, I am willing to do X if you agree. So one person signals willing to act, seeks the other person's agreement, creates a foundation of the negotiation. So here the government is like offering something. That is like laying road and collecting the toll. So offering something, or like building a infrastructure, say a dam or a port, whatever it is. Like they are offering something. That is the proposal. Acceptance is, yes, I agree to your person. The individual company or a public organization or an agency or an individual, like who is agreeing to that offer, who is agreeing to the proposal. So second stage is acceptance, accepting the offer. So must match the original offer exactly. So transforms the proposal time into a promise. And the third step is promise. Promises, we have no like mutual commitment because offer has been accepted. It has become a promise. So it creates, once it has been accepted, it creates a promiser, that is who is no offer maker, and a promisee who is the acceptor. So promiser here is the government because like they are offering me a chance to lay the road, and I can like take the contract from them. That is getting the contract from them by paying them some charges. I can like give them the a good like a good road like for the vehicles to pass by. So I am the promisee. My company is a promisee, and the government is a promiser. And the fourth step is consideration. Here's what the each party gives up. That is the price each party pays. How much I have to pay to the government. So what resources I can get from the government. So who are responsible for what? So that is consideration, because these things has to be mentioned in the contract. So that's why consideration happens. It can be money, service, or like anything. And finally, agreement is enacted. Agreement is made ready. So now we have a deal promised by the consideration and mutual obligations created. So once both party has signed the contract, signed the like agreement, legal enforceable happens. That is like now that is valid and like legally it can be enforced. That is, the law will back this up. Agreement plus legal enforceability. So that leads to a contract. So this is the contract formation journey. So first, a party has to give an offer, give a proposal. The other party has to accept the proposal. Then both get into a promise by promising themselves, like promising the one another that they will provide the service for this much payment or this much money. And the considerations will be like mentioned in the contract. Rules, regulations, everything will be mentioned in the contract. Then agreement is formed. That is, agreement contract document is like form, and both the parties sign. Both the parties give their like sign their consent, and like now the proper that is the agreement or the contract becomes legally enforceable. That is legally valid document. So 10 pillars of a valid contract. How can a contract be like made valid? Void is something where the contract becomes invalid. Void, VOID. So that is a phase where the contract becomes invalid. Invalid in the sense how a contract can become invalid. If any of the points mentioned in the contract is not applicable, or it is not followed, or it is no like particularly it was purposefully it was like omitted by either of the party, so then the contract becomes void. So, for example, say a rental agreement which gives a date for 1 year. So I am eligible to stay in the party's house for 1 year. But after 1 year, the contract becomes void because the date will be mentioned in the contract. So in those cases, contract will be void. And when I signed it, I didn't sign no with no like my full consent. I didn't sign with my full consent. Someone forced me to sign the contract. So under pressure, I couldn't say no. So that's why I signed the contract. So I'm giving a valid proof for that. Then the contract becomes void. So there are many reasons no for a contract to become void. So omitting all that, the chances of becoming a void. So what can be done to make a contract completely a valid one? First one is offer and acceptance, clear proposal from one party, and ambiguous acceptance from the other. There is no without any dilemma. The other party should also be accepting to it, and perfect meeting for mind. So first offer and acceptance is made. Second one is legal relationship is formed because both the parties now have a clear idea about who has a responsibility of what activity, who is going to pay for which one, and everything. So legal relationship is formed. The third one is consensus adhesion. That is not like meeting of minds. Both parties understand the same thing. So both of them has to agree to those points which is in the contract. And finally, fourth one is free consent. Free consent is this contract shouldn't be made to sign by the party by force or by a kind of pressure. So both parties have to have free consent, full consent and free consent of to sign to the agreement. The fifth one is capacity to contract. So there are many legal requirements to sign a contract. You should be having a sound mind. You should be 18 plus, and you shouldn't be legally disqualified. And minors, mentally incapacitated, or banned persons, they are not eligible to sign for a contract. Then if they they are forced to sign, if there is a valid proof to prove that they have been forced to sign, and the contract becomes void. And the sixth one is lawful object. That is, the purpose must be legal. It shouldn't be forbidden by law. It shouldn't be fraudulent. It shouldn't be causing harm to any others. It shouldn't be immoral or against public policy. That is the business activity mentioned in the contract. So it shouldn't be all these things. Then lawful consideration. That is not something valuable, should be exchanged. So that's why contracts are made, right? Something valuable should be exchanged, must be real and legal, can be past, present, or future, and quid pro quo. That is not something for something. See, if my house owner is going to giving going to give the house completely free. There is no rent, or there is no leasing, nothing is there. So out of some concern, or for any other reason, my house owner is accepting to give the house completely free. I mean, I can stay in the house till whatever time I decide. In this case, there is no need for a contract. So only if something is exchanged for something, a contract has to be made. If it is given with completely free of cost, if there is no exchange happening, then there is no need for a contract. So lawful consideration, that applies only when something for something is being done in the business activity. Then eighth one is certainty and possibility. So terms must be clear and definite. Performance must be possible. And ninth one is not declared void. Agreement not specifically prohibited by law doesn't fall into void categories. And the 10th one is legal formality. That is, it may require writing or registration, and it depends on the contract type. And some can be oral, others need documentation. But it depends on the business activity. It depends on what the other part, either of the parties has promised to do. and to till which time. So what is the deadline? And finally, like what has to be done, and who is who has to pay to the like who has to pay and who has to like receive. So all these things not considered like before this legal formalities are done. So contract classification, there are many classification in contracts. Let's see few. First is based on the creation and formation of a contract. The first classification, how the contract is created or formed. So express contracts. So this term knowledge is given to all the spoken agreements. That is for example, I'll sell you my car for 10,000, or I will lease out my property for say $50,000 per year, or I'll sell my say my land. Or I'll sell my company, or I'll make my company merged with your company. So all these like express contracts. There is expressing the wish to make a sale, to make a to make a trade happen. Second one is implied contract. So this is created by actions and not words. This doesn't need a contract actually, but the either of the people, no, both of the parties, no, they are obliged to do their responsibility, do their duties. Because taking a taxi ride implies payment agreement. So if I am taking a taxi, it means no, I have to pay to the taxi driver. Here there is no contract between the driver and me, but no, I am using the service, so I have to pay to the taxi driver. So this is an implied contract. Third one is tacit contract. That is inferred from party behavior. So conduct speaks louder than words. Example, regular service arrangements. So all the regular service arrangements comes under the tacit contract. Fourth one is quasi-contract, created by law, not parties. That is, it prevents unjust enrichment. Emergency medical treatment. So if I am checking into any of the hospitals for any such kind of treatments, so I'm not going to, one second, give me a second, just give me a second. Okay, sorry for the inconvenience. It was an emergency thing. Okay, fine. Yes, quasi contracts. So it is created by law and not by parties. It prevents unjust enrichment. That is, if I'm not getting what I want as a citizen, so then I can get help from the judicial entities. So there is no need to sign into a contract for getting those services, but I'm eligible as a citizen. So these are called as quasi contracts. So this is by creation or formation under this classification. The second classification is based on the validity period. So first one is valid contract. It meets all the legal requirements, fully enforceable by courts, the gold standards of agreements and everything. So it's completely enforceable, by the law. Second one is void contract. This cannot be enforced by law because the contract has become void, legally meaningless. And voidable contracts. Voidable in the sense either of the party can, in any phase of the contract, any stage of the contract period, they can nullify the contract by not taking any action. That is voidable contract. And the fourth one is unenforceable contract. So good in substance but technically defective. That is, contract is ready, but the parties have not signed the contract because they haven't come into a consent. They haven't agreed to the contract. So they haven't signed anything, but the contract is ready. Anytime it will happen. So these are unenforceable contracts. So unless or otherwise both the parties sign, the contract is not valid. And you cannot force, since the contract is ready, you cannot force these parties to come to an agreement and sign the contract. You cannot force them. That's why it's called unenforceable contracts. Fifth one is illegal contracts, forbidden by law, void and may result in penalties. All illegal contracts are void, but not all void contracts are illegal. So these contracts, these are the different types of contracts under the specification by validity. That is by validity. These are the contracts, like different types of. And third one is by execution or performance. There is executed contracts. Both parties completed their obligations. That is goods has been delivered and payment has been received. So executed contracts. Then executory contracts. That is installment purchase and purchase agreements. So you get the service, you get the product. So you're going to pay for it in installments. So these are executory contracts. So one or both parties still have duties to perform. So it is not over. And the fourth one is classification by liability. That is, who is liable to do what or to pay what. Unilateral contracts, only one party has remaining obligations. For example, if I'm taking insurance, that only I have the obligation to pay. If I'm not paying anything, the insurance company is not going to give me any service. So that's so simple. So it's a unilateral contract. So I'm going to take up the service from insurance company. So to get the service, I have to pay. So this is unilateral. And bilateral contractors, both the party sign into the contract, like employment contract or like a road contract or whatever it is. Like both the parties sign the contract. That is bilateral contract. Now let's see about. Okay, so offers. To sign a contract, first we have seen an offer has to be made by either of the party, either of the entity. Either the government has to come with an offer, and the private party or other public department or public service, they have to accept the offer. Then they mutually get into a agreement. So what is the offer? So let's see about different types of offers. First one is express offer. Express offer is clearly stated in words and written or spoken. That is express is immediately coming into an offer. There is no much discussions with the other party before giving this offer. So without any discussions with the other party with whom the business activity is going to happen, so a person or a government or an individual company or agency, they just express they are ready to get into a trade. Then is implied offer made through conduct action. That is bus company running routes implies passenger service. That is implied offers. So if a bus company is they are manufacturing a vehicle and they are run, it means they are ready to offer the service, a bus service to the public. So those are implied offers. Specific offers made to a particular person, like job offers or say project offers. So these are specific offers. For a particular person or for a particular group of people or to a particular department. So these are specific offers. So it is not open to public. It is not especially it's for the person. You have identified that person. So with that person, you are giving the offer. To that person, you are giving the offer. That is specific offer. Next one is unspecific, which is it is made to the public. It is not just for one person. It is made to the public. So whoever has the eligibility can take up the offer. And fifth one is standing offers or tenders. That is for ongoing supply relationships, cover extended time periods. That is government supply contracts. So there will be a contract time, and within that time you have to know, and there will be the rate and everything will be specified. So within that rate, within that cost which is specified by the government, and within that time period you have to give your service. So this is standing offers, or it is called as tenders released by the governments. So if you are ready to take up the tender, it means within the time period which the government has now like intimidated. So you have to complete the task. You have to complete it and hand over it to the government. So counter offers, no, like immediately, no, like the offer is made. So negotiations happen very immediately. Uh, Initially, it may be an express offer. Initially, when the trade has started, maybe an express offer, but it can change into counter offers. Then finally, cross offers. That is two identical offers made simultaneously. But the hint here is neither of the party will be knowing that the other person has also offered, is ready to take up the offer. So this is cross offers. So these are the various type of offers, you can see in like government administration departments and like in private companies as well. Okay, now let's see about our Indian contract law. That is in our country, we have this administrative law, the Indian contract law. So let's have a key points, about it. Let's see, what it is. So it was enacted in April 25, 1872. That is during the time of the British rule. Then it was commenced from September 1st, 1872. So there were totally 238 sessions. And it coverages like all the Indian states except J and K at the time of enactment. That is not like because in those time, it was princely states. That is not like kingdoms were ruling. It was not ruled by like the chief ministers or governors, like as we are, because we are in democratic country right now. But before that, it was like princely states. So there were a particular region, like a south region or southeast region. It was like ruled by kings or like the the offsprings of the great rulers and everyone. So those princely states came under this, Indian contract law. It was enacted, it was solemnized, and it was same for all the princely states. But Jammu and Kashmir, that time, it was not included in that. That was also a princely state, but it was not included. So there are two main parts. So part one, it speaks about the general principles. So from section 1 to 75, it's all about the general principles of this Indian contract law. So it speaks about the foundation of contract law, that is from which source the law has been enacted, and what are all the factors which has been considered before enacting these laws, and which party was involved for enacting these law. Everything, this complete foundation of the contract law will be mentioned between section 1 to 75 under general principles, and these universal rules is applicable to all contracts. And part 2, it speaks about the special contracts. So from section 124 to 238, so it all speaks about the guarantee, warranty, bailment, pledge, agency relationships, and everything. So I haven't taken many points about our Indian contract law, because I thought just giving a few hints about these things, that makes sense. Now, as a an individual, if you're ready to take up a government contract, ready to accept an offer from the government entity, or your company is now your company is planning or already into any kind of government contract. A few things we have to have it in mind. First one is any contract before signing into, once you have signed, be very sure these contracts, we have read all the points in the contract. Without reading all the points, without understanding those points, never sign a contract. So second one is, once you have signed the contract, it means you have to strictly adhere to all the points mentioned in the contract. You have to strictly adhere to it. So if you are not adhering to it, you will be liable. You will become liable to the other party, because with that contract, with that proof, this party, the other party can take any judicial help and make you pay the compensation. So they stick on to those like rules, regulations, whichever is mentioned in the contract. So third one is, before signing, you have to like consider many things. There is like just for profit purpose nowadays, like people signing the companies sign, and then finally like they get into any legal dispute with the government body or with the other party. So before signing into the contract, consider all the things. Consider your employees, the other employees in the organization, consider the organization, consider the top management, everything. So only if your company, if your organization is going to get benefited, if not immediately or maybe like after some time, only if they are going to get benefited, like on some like something, so go for the contract, sign in the agreement. But if it is going to be create any if by signing the contract, if it is going to be like something problematic is going to happen like in the future, so better don't sign the contract. So these things you have to keep in mind before signing the contract, because once you have signed, it becomes like legally enforceable. You cannot escape from it. So, as a conclusion, the valid contract is like, first the offer has to be made by one party. It has to be agreed by the other party. It means both are ready to do a trade, get into a trade, and after considering all the like legal aspects and positive and negative everything, and they come into a legal intent and sign, and that becomes a valid contract. So the three contract truth is, not all agreements or contracts. That is, legal enforceability matters. At the same time, not all the contracts are considered as agreements only. And capacity and consent are crucial. Be very sure if you have the capacity, whether you have the capacity to complete the task which is mentioned in the contract, the capacity not to fulfill the requirements which is mentioned in the contract, or the capacity to make the payments, like which is mentioned in the contract. So only if you have that capacity and if you have the full consent, without others pressure or without others like like a force, so you can get into the contract. So parties must be able and willing. The third one is, legality is non-negotiable. You cannot negotiate with the legal bodies, because you have signed the contract. Once you have signed, it becomes legally enforceable. So illegal contracts are void. So what are these illegal contracts? How can a contract be like illegal? Illegal in the sense, like government like list a specific like things which is illegal in that particular country. For example, mining in a particular region, that's illegal. Government has prohibited that. But you're entering a contract, with the, you're bribing someone, in the government, and your company is bribing someone, in a particular department, government department, and you're, like planning to mine that region, like exert the resources and, like making profit out of it. It's completely illegal. And export import, if the government is asking to they're planning to procure from your company, procure the resources from your company, because your company is manufacturing something. Government is like planning to procure it from you, and they are like planning to export it. So few like things are like prohibited in the country, right, for export, or like to other country, where they are importing, they may be like having some prohibited item. So you shouldn't be doing that. But if you are like entering into a contract by signing into it and like doing the things illegally, it becomes an illegal contract. So you will be like your company will be like punished in the name of like compensation. Sometimes dissolution will also happen. They may not dissolve the company. So always ensure clarity in the agreements, verify the other party's capacity to contract. Like identify whether the other party has a capacity to fulfill the requirements which is mentioned in the contract. Keep the proper documentation, understand what makes contracts enforceable, and know your rights in different contract types. So we have come to the end of the session. I'll stay here for 5 more minutes. You have any doubt, you can clarify.
Hello, ma'am.
Yes.
We signed the contract and in between the product price will be increased. Is this possible to change the contract value
No,
amount,
no,
ma'am?
no. No, it is not. No, it cannot be done. It cannot be done. Once the price is no like fixed and mentioned in the contract, that remains the same. It can,
Depending upon the construction field, the price will be increase or decrease, ma'am. And
no, you cannot change it. Even no, not only in the construction company, in any company or industry, once a contract has been signed, no, you cannot change it, because only after that time period which is mentioned in the contract has become void, then only you will be able to change. So if I am renting a property, say for say 15,000 per month, and I have no like myself and no like the how property owner has signed a contract. In the same locality, if the other no like proprietor of another property has increased the rent, my house owner cannot increase the rent, because we both have signed the contract. So for 1 year I have to pay only 15,000. My house owner cannot increase it, because no the price of the property has no like increased. He cannot do that. if,
okay,
if, if
ma'am,
he
got
is
it.
not like forcing me, if that party is forcing me to know like to change the contract and anything, I cannot get any no like judicial help. I can sue him. I can no like make him pay the compensation.
Who is the contractor signing for authority, ma'am, for organization?
The president, the highest official, will be signing the contract. The
The
highest
president
official.
or C. Okay, ma'am. The president or CEO change the organization. His contract will be valid.
Yeah, yes, sir. To make the contract valid, it has to be signed by the highest official of the organization.
The
The
CEO
provider.
change the ordinance also. The contract will be the contract will
I
be valid or not valid, ma'am.
I didn't get you. Sorry.
The CEO changed the contractor, ma'am. The organization changed, ma'am. The contract
Mhm.
is valid or not valid?
In that case, what can be done is the other authority, no, in that organization can speak with the other party that the CEO has changed. So instead of no like the CEO's name, the new CEO name will be mentioned in the contract, but with the consent of the other party. With the consent of the other party.
Okay, okay, ma'am. Okay, thank you, ma'am. I got it.
Yeah. Yes. Okay. So Saran, you have asked. Okay, if the homeowner or contractor dies before completing the work and advance money is involved, collecting that money or refunding it, how to collect it? You can only collect it from the person who are not closely associated with the homeowner. I mean, from his family, if it is an organization, from the organization, because contract is valid. So you can get it from the close associates of the party. So Muhammad Ibrahim Shah has asked, what is contract duration? Minimum, maximum duration. There is no maximum duration, but I mean minimum, maximum, it is decided by the parties, no, whoever is getting into the contract. Maybe for 1 day, or it may be for 1 year, it may be for 5 years, 10 years. It depends on the task, it depends on the activity, it depends on the time frame and everything. So there is no minimum maximum duration under. In case of government contracts, mostly it will be for years. There will not be like any short term duration. Mostly it will be long term duration, because government undertakings it requires lot of time. See, construction infrastructure and all, no, it requires a lot of time. laying the roads, constructing dam, building the ports. It requires a lot of time. So mostly in government organization, if it is a government contract, obviously no, it will be mentioned for years, minimum or maximum. No, it can be for years. But otherwise, if it is a private contract, it can no go for 1 day with the minimum, or it can be going for no even hours. It can go for even hours only. So the parties can decide. Yes, any other questions?
Sometimes national disaster will be happen, ma'am. This case, how will you treat it the contractor? The contract will
National.
be extended to monsoon or raining seasons. It will be take more 2 months or 3 months. It will be possible to extend the contract.
It depends on the no like the parties, because see, for example, uh, these things, no, these occurrences are no like something unexpected. It is not no like purposefully done. Say a tsunami or no an earthquake or no heavy floods, heavy rains. So all these things, no, like it's natural occurrences. So in those cases, no, like things can be considered. Either the parties can no consider the contract. They can extend the contract. So that's not a problem. So, for example,
Okay.
no, like here, I don't know, like whether you were here, no, before moving there. What happened in the time of COVID? Banks, no, like they have extended the contract period of loan repayment. Whoever has no, like taken a loan, personal loan, or no, like whatever loan they have taken. So during COVID, no, like many has lost their jobs. So in many organizations, no, like work was not going on, job was not going on. So what banks did was no like the Reserve Bank of India instructed the banks to stop, like forcing the all the lenders, like I mean all the loan takers, like to pay back the loan. So I think no like banks have given a maximum of 6 months time. No, they didn't force the all the loan takers to like pay back the loan. So it was not like given. So those considerations were given because these are natural occurrences, right? So those can be considered.
Okay, ma'am. Thank you.
Yeah. Yes. Any other questions? Okay. So in that case, we can know like end up the session. I'll see you in another session. Bye and have a great weekend.
Thank you.
You're welcome.